In the business world, the termination of business activities is often unavoidable. Reasons include court decisions, fulfillment of company's purpose, or financial difficulties. Just like there are obligations at the beginning of business activities, there are also specific duties to be fulfilled at the end. Join me in today's episode about the risks and tasks of liquidators, compliance, and closure. I'm Richard Hoffman, lawyer and partner of Akevis International. Let's get started. In accordance with the legal framework, both a legal entity and an individual with full legal capacity can be designated as a liquidator. Unless expressly stipulated in the company's articles of association, the managing director of a limited liability company assumes the role of the liquidator by default. This appointment as a liquidator does not in any way impact the existing contractual obligations of the managing director. Moreover, it is also possible to designate third parties as liquidators, either through explicit provisions within the company's articles of association or via a resolution passed by the shareholders' meeting. But what does a liquidator do? This position comes with many tasks and high responsibilities. Let's start with preparing financial statements. The liquidator's role begins before the liquidation process. They prepare the closing balance for the last fiscal year, which is important for the financial statement. It consists of the balance sheet, profit and loss statement, and an appendix. They also create a liquidation opening balance sheet, which shows the assets during dissolution. Liquidators of a limited liability company are obliged to register the dissolution of the company at the commercial register, so the registry court at the place where the office of the GmbH is registered. In step 3, the actual liquidation begins. The announcement in the Federal Gazette must include a call to creditors to submit their outstanding claims against the company. With the start of the publication, the 1-year waiting year starts. We have covered the waiting year in another video, so please tune in if you haven't already. During this 1 year, no company assets can be distributed to the shareholders. The termination of ongoing business encompasses the entire business activities of the company. Outstanding obligations within existing contracts can still be fulfilled. Via collecting claims and receivables, company assets are distributed to the shareholders. Creditors are identified through evaluation of company documents. Order of settlement is determined considering expiration dates and due dates. If not all creditors can be satisfied, the liquidator must file for insolvency. A reference to the liquidation process shall be indicated by the 2 letters IL. After preparation of the liquidation closing balance sheet, which outlines how the distribution of the remaining assets to the shareholders should occur, the money is paid to the shareholders. The payout is done by the liquidator and distributed proportionally based on the value of the shares held by each shareholder. Final account is a document providing an overview of the entire liquidation process, documenting the actual distribution of the final assets. The deletion of the company in the commercial register can only be registered if all assets have been distributed, and no further winding up measures are necessary. Tax matters must be settled beforehand as well. With the conclusion of the liquidation, the liquidator declares the termination of the liquidator's office. The liquidator bears the responsibility for the proper and regulation-compliant winding up of the company. In certain cases, they may be held personally liable for culpable conduct, referring to errors for which they are individually responsible. Personal liability may arise, for instance, if the liquidator fails to adhere to the blocking period, with the obligation to compensate any resulting damages to the company. Furthermore, the Federal Court of Justice, BGH, has established that creditors also have the right to hold the liquidator personally accountable for any misconduct. It is crucial to note that such liability can have significant financial implications for the liquidator. Upon identification of the company's insolvency during the liquidation process, the liquidator is obligated to file for insolvency. Non-compliance with such obligations can lead to both civil and criminal liabilities. The law stipulates a potential prison sentence of up to 1 year for the infringement of the obligation to report losses. In summary, it is emphasized that company liquidation is an extensive process. Our attorneys and tax advisors provide comprehensive support throughout the entire process, ensuring a very compliant dissolution with all legal requirements. Our experts also oversee the financial aspects of the process and prepare financial statements, liquidation balance sheets, and tax returns. Contact us today and thank you for tuning in.